small as Singapore is, as a common law jurisdiction, we do have a sizable body of respected scholars of international standing in our law schools. Before I conclude, I would like to make a final point. Law academics often see more or less in a judgment than the court has decided. It is usually not their fault. They are not privy to the deliberations of the court. So let me give you a few examples by way of clarification. First example is from a paper on conflict in land law jurisprudence. In that paper, it is stated, and I quote, "Two different attitudes may be discerned in the Singapore cases on collective sales. The first approach is articulated by me in the Phoenix Court case, is that, and I quote, the legislative amendments made to the collective sales scheme in 1999 are intended to facilitate and not to place unnecessary obstacles in the way of collective sales. Under this approach, the court ought to strive to facilitate the will of the majority to sell the property collectively, so long as the sale was not tainted with bad faith. Furthermore, the court should not frustrate the majority's wishes on the grounds of technicalities or procedural irregularities, if such matters do not cause prejudice to the minority owners." In contrast, in the Horizon Tower case, Justice V.K. Raja expressed some doubts as to whether the minority owner's interest has been adequately protected in the statutory scheme. Justice Raja said, and I quote, "It cannot be gainsaid that in establishing the statutory scheme, collective sales, Parliament had certainly considered both the rights and financial interests of the objecting subsidiary proprietors. So stemming from this skepticism that the minority owner's interest has been adequately protected, it is unsurprising that Justice Raja listed an extremely comprehensive list of duties that the sales committee must comply with in a collective sale." So this is the quotation from the paper. Now, this passage gives the impression of a divergence of approach between Justice Raja and me on the protection of property rights in en bloc sales. It makes Justice Raja out as a champion of minority rights and me as a champion of majority rights. However, I should point out that in both cases, the appeal panels consisted of the same 3 judges, and both decisions were unanimous. The passage also gives the impression that the court is inconsistent in its philosophical approach to property rights. But the fact, of course, is that in one case, the majority was in breach of its fiduciary duties to the minority, and in another case, the minority was trying to use technicalities to frustrate, the will of the majority.